yankwa na mini lawyer Martin Pegbu na wobekaya wono so oyemranimu ni de nsem bebre wo a decided cases e Supreme Court a ono anso da bia ye refer no to law me moche
yeni atikesi enia
ma fi wo bra anan mi hwe TV so aye kese nam se de de no odi o mam bie
well adumara kwa
yo enra Supreme Court tena yewura Kevin Taylor nasem no so de ode kodan wo mo no na for one decision by in favor say quashes that arrest warrant no nipa bebre nso so with different thoughts about those things. He said the warrant was to for him to be brought to the court no nka say omra ne yemfa ntum na said the ekosisi minim say what tie commentary bebre ni nkomo kwa yedi na no pay eto say
yeah okay nti ne edi kan ya meka ne say mini Kwame Addo ono ne interview na meche ya meka say mama me nka
amate
so ne oka say Supreme Court ni omoye no da no o ma stand the law on bench warrant ni but we need the mo amene ne nya adwen kura anti men point number 2 obi obeka say no da Supreme Court decision Kevin Taylor assistant law on bench warrant ni e keka on patro dey bi antisa no number 1 Kevin Taylor case no any criminal case into na point number 2 ni say because here baby I already free act 30 nyina it doesn't apply
because any criminal case
Kevin Taylor any criminal case before the court.
Oh okay patro na contempt.
Yeah,
contempt you can be committed into prison custody.
Yes, and the fact that you can be committed to prison custody and no interest a criminal case. Your friend and you quasi criminal. Quasi. Into a criminal case ankasa. So answer say you bua for contempt na o file form wa American embassy. Part na and UK. Part na they decide say have been convicted of a criminal offense. No better today people. Yes, when we find you liable on contempt, it is not a criminal offense. If you fill a visa form and not any other form, say we could be you decide say well, you will for a criminal case. I'll be today because I know any criminal case. Okay. Yes, so let's note that.
Lorry, a criminal case, a DNT ma court no issue arrest warrant.
Yes. Into a contempt of court. That the case before the court was contempt. Into if there's a contempt case against you and no na if only the judge na somehow na se one bar. Into what the Supreme Court is saying is that it was said anka Justice K Banfu odi kan somehow Kevin Taylor. But Osha Kratana one samano. Now let me show you cases express or told samano. Only a friend is a Munchi tray.
Yeah.
Munchi says, Omuye this no. Yes, send you almost summons. Young Cathy go and arrest them. Let's send you summons. Say, Yakisa Usi say, into Brabi you run not. Into Saban, you that's a one bar. Your issue bench warrant. That's one. Apart from Munchi three case, no. Someone in Pesa White, just recently, before the election.
Pesa White, Dr. Pesa White.
Yes, so we are continuing. Yes, there no summons. Then, which other case? Sir John Mooney, that's the same thing. So the Supreme Court made it clear. And I know Kratos, Attorney General.
Lord, but you are saying,
and that one, Attorney General, no, but another court, no, registrar. But don't just issue a bench warrant straight say Yankano. There's never been any law like that. Near yet treat direct and you said what back court, Judge Yeni Juma, now we in a court or try ampia who ye did. Into why you were judging him and none of the Casamon channel. But will be TV online. TV Sony one you were judging him, judging to me channel straight. Into another threat, contempt ex facie courier. Like it's a 1 year was judging in one funny could see a or the could see a room that was in the port. Oh, yes, I am not because one channel. So there's a different pattern. Now go ahead.
Ayi Lord na me bisa ne say na kire say ese say one court ni issue summons.
Yes.
Na want me ona ne appearance na then arrest warrant may be issued.
Perfect. No. Until the kind summon no man summons. Until one bar.
Whereby the person is outside the jurisdiction.
Excellent.
And also to say,
you take steps to bring it to his attention. You cause them to send munim the email among Sunday or by order munim the WhatsApp number and more sending munim any TV. So try those ones. So there will be able who say, oh, I did a TV. So I had Kevin Taylor will be or Papa or this in Ghana. Then apart from that, there are 2 online Ghana web various portals. No. Even Kwaku Annan Loud Silence Media, there is email information there. Now, Mama email, all those things. If people try 5, 6 weeks, and you'll be able to say, oh, what you are now, that's it. I need here. Then that's the one you now go ahead. Now, we should, be able to say, oh, I beg. I can tell her, what you online, I send TV to Ghana, so to Ghana, seminar. We are black or radio so near. I know the only issue bench one because because the law cannot be 200% perfect.
Okay. Now, Lord, Mamma, we are dear bill. Bra, now you can't a warranty and was say no. Per the Supreme Court decision, no. Ma case a walk high court ni I moot on.
Yes, but it doesn't mean that the court cannot start again. The court cannot start again. He said, you court he said, oh, still was he DSM now. And the court registrar on the year summons. Now, as your master Kevin Killer, so Ombra. If they see Rama Quine, in Kasi Muta, young Cassie, Yen Asem Nan Casa. Asem Nan Casa say, in some no kind, in Yana Supreme Court, Supreme Court procedure, now judging. A fast with the issue bench warrant and as Supreme Court it by India some man catch up near so kind one co and you know a day you do honor your people. Now I say Kennedy Agyapong dear no say all kind say bench no court say we are no for.
Yeah.
So did he judge at Kennedy Agyapong did he justice winter when you attempt any eventually and we say Supreme Court stop pay judge no say judge na nko no anka say baby di asem no say ono na Kennedy Agyapong didi na attempt no Supreme Court stop pay say oh massa one kasa the main case but the case no to different judge ni Justice Jima and no we have Kennedy Agyapong for if we are no for if we have Kennedy Agyapong contempt. So if this one they want to do it, yes, they can just restart and do the right thing.
Me pacho ora Kevin the no na ye the Republic versus Kevin na interested party na ye hwan.
No, there be net the no na ye abra no mudi Eugene Bafo Bonnie asem no Eugene Bafo Bonnie PTV etc. The Muna National Security NCA case no. Into mudi case no air coso up and down no not just say back na oye tembuafo and no almost say allegedly Kevin Taylor can send you know and no in the case be na a work against him but case it say John any Sammy Ukumu abra the election petition no mo can send the
matter with a subjudice no na what one wakotum
and no be na bass.
Oh okay no watch them yi pa ama yenso so ene yate ase na owura Dr. Kwabena for and 9 others wo mo se agya wo mo na enu no binum so hwehwia so se ye ni law bia se nipa no one so convict nansa ansa na bia plea bargaining kwa wo na ye na mrabe na kire se obi afo man sika ase twam 60% tutu a obekọ binim se wa follow se de ekono a nkrofo ma legal commentaries wo ho a
yes, but your friend case me
Martin, bye. Lawyer Martin Kweku Lawyer Kwame Adofo a private legal practitioner. Yene ne ntwetwe enkomo e fa nsem bi ehuhiam e wo emremu. Law, kaso me mo ache.
Aso voice no watch kakra o.
Kaso ye.
Ye kakra.
Mate pa. We dia akwa se akwa bi Jesus sa na yare. Na wati na nima no, wo hu se nipa. Was wo nipa se nnua. Ne sa yi. Law, and when you mammy favorite Supreme Court 4-1 decision, a woman there a buy if I were Kevin Taylor, the other called down one more a far new warrant and want some arrest warrant and want some. It will say a dear banana if we are Sebache.
I'm in show, tear for ne or her for ne or more. Union Mono moved to the movie. Look, 4-1 split. Just say. Judges in Ankazangasakra, they disagreed among themselves. Yes. They disagreed among themselves because are unanimous. That's it.
Okay.
4-1. No. This will be a test. Ruling Nankasayasaka. A test for law students. They will be reading it and they will tell us why the one judge did not agree with the others. And it means that as commentators, yes, also likely we are going to disagree.
Na law mami musadle bi dia meti ye wo mu ni say decision no a majority of the Apex Court of the Land, the Supreme Court judges no ejina so ni say necessary e ma no kwan e ma kayetie nasem e wo ho ansa na bi a ya committee to contempt or ya man arrest warrant no ne ade be ni person o mai why na ya man arrest warrant agisi etie no ansa na man arrest warrant
eno ni asem no eno ti na even themselves, the judges disagree. You see, it means no court can order a warrant to arrest anybody anymore. Since answer was no. It means bench warrant now. While my court issue for you to be brought to court is now being rendered nugatory and also useless. Because the position of the law, they say, bench warrant. Who if you read the act, the court act near dinner, and the court can issue bench warrant when you don't come to court. It means come to court, come and tell us why you are not guilty of X, Y, Z.
Summons should be a criminal summons should be a come and show cause.
Yes. So there's nothing wrong with say we issue warrant for you to be arrested. It doesn't mean you are guilty of any offense. See, you are convicting. See, this is the distinction. Then it makes sense why you did not hear him before you convicted him. The man has not been convicted. The court wants him to come and then show cause why he should not be convicted for contempt. It's a warrant issue day to day against everybody or anybody who fails to come to court. And they say police officers in a court not asking for bench warrant. It means that the court now cannot grant it.
Oh, sanity.
Was it?
But it will be a dangerous precedent.
It is dangerous. I don't think that judges now they could not agree. The judges themselves could not agree because some of you said, for you to come to court and you say you are not coming, the only remedy available to the court is to issue a warrant for you to be brought, which is what has to be done. Otherwise, you are not coming. It is issue warrant. It doesn't mean that you are guilty of any offense. The court has not said Kevin Taylor is guilty of any offense at all. What the court did, they say, was a certain video has been brought to the court's attention of somebody insulting the court, and therefore produce him before this court to answer. That's the underlying word, to answer to the question of why he should not be committed for contempt. That is what we call police natural justice and alternate pattern. The court.
Law, Mr. Kuta, Criminal Other Offences Act procedure no 1960.
Correct.
Now, what kind section 71 now? Well, it was the issue of warrant of arrest. A warrant may be issued at any time before or after the time appointed in the summons for appearance of the accused, although a summons may have been issued.
Exactly.
Now, two no swap or say a warrant shall not be issued under subsection 1 unless a complaint or charge has been made on oath. Now, over 72 no was a summons disobeyed, where the accused does not appear at the time and place appointed in and by the summons, and the accused personal attendance has not been dispensed with under Article 70, the court may issue a warrant to arrest the accused and cause the accused to be brought to before court.
See, in a way, the court has now made Act 30 that provision already.
Act 30, yeah.
Useless. But you see, courts are not, they are subservient to Act of Parliament. The law is made by lawmakers, and courts interpret the law. That is the position of the law. In interpreting the law, it's almost say he needed to be given a hearing before a bench warrant is issued. Meaning that it's a police officer at court. Not say, a year, or a year. And so, many people who know. But when you're not hearing before you get bench warrant. Meanwhile, if you look at this warrant, that's an issue here, or quashes and right. What's it? Bring him, he has to be produced before the court to answer. That's what we call natural justice. Audi or terror party rule normal can. After was saying, come and answer. So the judge got it wrong. He hasn't convicted Kevin Taylor. So this is going to be a very fierce debate among law students.
Because they say no, we'll be to court to see a issue arrest warrant.
Because now the judge, the Supreme Court is giving him a hearing first. Keep him no. How do you give him a hearing? I don't think the judges know themselves, they could not agree. That's why I went for one. Because how do you give somebody who is on the run a hearing first?
Now, Attorney General no bet me go review. Meanwhile, say no anko so amba.
Attorney General was the interested party. You see, Owusu Agyarko, he was served with the processes. As an interested party, he ought to have gone and argued against it. Oh yeah, another one.
I said no. What to me? I'm calling. Say
it means that what by ambassador, you are free, you are above the law.
Na me ba me bo say ama case na substantive case no ankasa na na ese oba na ye betie na no asem no aye moot ana say again.
It's moot. Now he is no longer required to go to any court.
Oh wow.
To answer anything. Because the warrant has now been struck out. It means that now there's nothing for him to go and answer. Nobody is asking for him anymore. Because you see the practicality of this, it's impossible for you to give somebody a hearing before you should issue a warrant for his arrest. How do you give him a hearing before you issue a warrant for his arrest?
I see. Me patcho meet you.
And also, it's an act of parliament.
Yeah, an act of parliament, yeah, sure.
Yes. Hey, where the person fails to come to court, issue a warrant. And the police for any warrant, or all police warrants will now be set aside. It means that now, Ken Ofori Atta, the warrant has to be set aside.
Anybody bet me a Owusu way? Yes, case be so adjudicated on its own merit.
Matter. When the Supreme Court speaks, they set the law. They have now set the law. Say, for you to even issue a warrant, you need to give the person a hearing. That's what it means. If the OSP warrant no issue, it means that it's now a nullity because he hasn't given Ofori Atta a hearing. It is also a judgment. No.
Wow.
Master, we are in for a big storm.
Wow.
All warrants issued before yesterday are now going to be questioned because you did not give the person a hearing. Now, how is that practicable? The practicality of it is that it's not possible for you to give somebody a hearing before you issue a warrant for his arrest. It's your jubilating now, they don't know it's as well. It's a police officer to be mama because there's a whole fugitiveness of my hearing and a court are granted. That is what will happen.
Eti obi betimi arane to the Supreme Court. Ebra ye issue arrest warrant the amano say man hearing answer.
That's what it means. Of course, our authority indigenous. It will at the Supreme Court, depending on the panel, we decide to set this ruling aside as wrong.
Okay.
Supreme Court can change its ruling anytime.
Right.
So what is the mechanism?
Me too, pa.
So another bench will say no. We got it wrong with this ruling. We are setting aside. Otherwise, now it means that no police officer can go to court and apply for bench warrant. Because if it's granted, it means that it's a nullity because you did not give the person a hearing. That's what it means.
And Act 30 no so a procedure a kwanya as of us.
No. My yes, my year cases are police officers arrested my client, put him in prison, police cells for 13 days. I sued the police and I quoted this act, and the judge agreed with me. Hey, the purpose of bench warrant is not to go and arrest the person and put the person in prison. No, you arrest him and bring him to the court immediately. It's all that warrant against Kevin Taylor was supposed to do is that he was supposed to be arrested, brought before a court, and the court will discharge it. See, it is there second no back room has 2nd July to say Obay. Almost airport. No, the court, not court to discharge it. Bench warrant. There was no need for even Supreme Court to them to take this case to the Supreme Court.
Okay.
What did the mechanism?
Me too, pa.
Because bench warrant, it doesn't say put him in prison. No. It just says bring him before the court.
Oh, okay.
That's all it means.
Yes, Kwachin Kotum Debbie.
Debbie. Arrest him and bring him, produce him. It's not a commercial airport. Name that is here. Academia airport. They had at the court. The court are granting the bail. Finish. There was no need to go to Supreme Court. They say what is the Supreme Court is changing the whole position of the law now. Meaning that now ordinary bench warrant issued to police officers is now a nullity.
Wow.
Yes, and so Supreme Court better assist position.
I see. Now, been more any about wanted. Nebia, you don't pictures about days. And
the man catch you say, Ken Ofori Atta case, Now it means it's a nullity. Because the warrant was issued to these people without hearing from Ken Ofori Atta. Kevin Taylor's case has now changed the position of the law.
Okay. All right. Now, Lord, Mama Samra, and also another landmark a year by any say, Dr. Kwabena Agyapong and 7 others, so no, Jai Womu, na issue near Sikabia, na a year, my dear, a could do Womu. Aha, Sikabia, a could do Womu, na yes, Womu, and she says, Womu 60%. And a man who can see Jawomu. Plea bargaining acts, no, saying a kafa sadi any day is still no.
Nana, there is no law in Ghana that says 60% to down. There's no law. What the Attorney General was saying is a lot of crap.
Why?
There's one court to law. The law, no position of the law, say, even under the Court Act, you can enter into an agreement with the prosecution to provide compensation in lieu of going to prison. But you have to be convicted first. Aha. It means to say, so we are Abayasika, and after through certain circumstances, Abayasika becomes a financial lobster. You can enter into an agreement and say, oh, I'll pay X. And if it's acceptable to the state, the state is okay, pay X, but you have to be convicted. It's not available to somebody who is not prepared to be convicted. I don't know Ato Forson.
Yeah.
He agreed to pay a certain amount, which was accepted. It's more like terms of settlement. But if you fail, it means that you have to. So Ato Forson was convicted first, and he was given an opportunity to pay. Failing to pay, then you go to prison.
Okay.
That is what ended Ato Forson in prison.
Oh, okay.
There's no law. And I was quite reading it. I was really quite curious to see which law he was going to cite. Once I did law,
one call to authority,
one guy, one go to read. Pay, kind
Mati.
And one say with 60% and it's blah blah blah.
Let's say, you can't put something on nothing. So, in absence of any law like that, you know, you then not come by that 60% at the end.
Friend, no, Nebusano. We was always maybe he is best. But you see, the truth of the matter is say, NDC people who were charged, the lawyers that were involved, they happen to be the Attorney General or people working in the Attorney General's former office, the Deputy Attorney General or Deputy Attorney General's former office. Now they find themselves in government. They are going after their former clients, which is what we call conflict of interest. You are not allowed to go after your former clients. So they are in a difficult position. Say, how do I now represent the state against my clients? And Untina, almost find a way to make all the cases flesh cases. You know, almost continuing cases. Because you are not allowed to go after your former clients. And Dr. Dofo or the other ones, they were represented by either the Attorney General himself or their office.
You can't go after your former client.
Correct. That is the position of the law. It's like me now, Kwame, we are my client. I cannot in the future go after you.
Obi case be and I similar no behind.
I'm not allowed.
Oh wow.
That is why they find themselves in a conflict of interest. So they need to find a way to overcome that conflict. And that's the truth.
I see. No.
Attorney General. And I will Kwame, who is my former client. Why I'm not allowed to touch your case? Because you've been in a position before. I was confiding in me. I know all your vulnerabilities.
Yes, I know evidence. Okay.
I know all your vulnerabilities. So, Pamno, don't go after your former client.
Wow.
I don't know. One more final one said they are in conflict. And over here, they drop those charges, finding flimsy excuses which hold no water. Yes, I call you and say, I said, refer those cases are one older in Sakano. Emma special prosecutor, because that's what the law says. And this one is important. He's a special prosecutor. He's not on his own. And people are mistaking the special prosecutor independent. No, they are wrong. The act says he can only act when he is authorized by the Attorney General or Parliament. Authorized by the Attorney General or Parliament. Or what in front of it has to be challenged.
Baba, there were other subsidiary legislation or what? I don't
understand.
Sir, there were other act to be a Parliament a pass it. And I'm a fan so no special prosecutor. Say I am rather batana.
Yes.
Always a special prosecutor, operations regulations 2018 LI 2374. Yeah. If you want to mean you know, I'm fine without recourse to the Attorney General.
And to say what? You have to go back to Attorney General for authorization.
Oh wow!
Because in the airline, no, simply about procedure, how to go about things. But you have to be authorized. No, Attorney General. Finding himself in conflict, the asset or refer those cases to the special prosecutor as an independent person to take over. That's what they are here. That's what the Attorney General ought to have done. And to be someone to go back, you know, and he's not prepared to give it to the office of Attorney General the idea on discontinued cases. And then when they say, we just out home, that, you know, this is where we follow. And the man who's a Ghana, you need that to be a
Mati. Lord, Mamma was not missing your pamphlet.
Thank you.
Mr. Medasipa. Kwame Addo Esquire. We're a private legal practitioner and now trained.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.